video, I want to talk about what is evidence. In earlier videos, we've discussed that you need evidence if you're going to win your undue influence claim come time of trial. And we got some comments on those videos that said, but what is evidence? We didn't answer that question. What is evidence? Well, in its simplest form, there's three types of evidence. There's facts, there's witnesses, and there's documents. And most of your facts of your case are going to be introduced come time of trial through either a witness or through a document or through some combination of both of those things. Now, obviously, undue influence cases are difficult because the best witness for what happened when the trust was created is the person who created the trust, but they're no longer here. In all of our cases, that person, the parent or whoever created the trust, is deceased, and that's how the beneficiaries found out they were even disinherited, and that's when the lawsuit starts. So the best witness we could possibly have is typically no longer with us, and so we can't bring them in to testify, obviously. So what that leaves you with is having to find other evidence. Almost all undue influence cases are proven come time of trial through what we call circumstantial evidence, not direct evidence. And that's because the decedent isn't here, so we don't have their testimony. That would be direct evidence, but it's gone. And the person who engaged in the undue influence, they're not going to come out and say, yes, I unduly influenced the elder or the decedent, whoever they were. And so that direct evidence is not available to us either. So instead, we get into circumstantial evidence. Circumstantial evidence is things kind of around the edges that would establish that you're probably right that there was undue influence. So for example, one of the elements of undue influence is you have to have an elder who's susceptible to being unduly influenced. Susceptibility includes things like a mental condition, dementia, Alzheimer's, stroke, or age, or illness. There's different factors you can look at. So you can go to the medical records and you can look in the medical records. You can consider what their condition was at the time that this bad trust or trust amendment was created. And you can start putting together that documentary evidence. Now, the medical records in and of themselves, by and large, cannot be introduced come time of trial because they're hearsay. So that means you have to hire an expert witness, which is usually a doctor. And that doctor is going to review those medical records, and then they're going to give their opinion. And that's what you use come time of trial. The doctor's testimony of their opinion of whether or not the elder was susceptible to undue influence becomes the evidence you use come time of trial. Another point of evidence are disinterested witnesses. So maybe the decedent had a very good friend and neighbor who was around all the time and witnessed certain things. And maybe they saw that the person who received everything wasn't very nice to the elder. Or maybe they had discussions with the elder. Well, the elder said, I want to make sure I leave my estate to all my kids equally. And yet that's not what occurred. And so that disinterested neighbor becomes a very strong witness. Another witness you're going to have in almost all of these cases is the drafting attorney. Most of these trust or trust amendments are drafted up by an attorney. And you're going to need to depose that drafting attorney and take their testimony. And if you're trying to contest a trust or a trust amendment, sometimes the drafting attorney is not going to be a good witness for you. But on the other hand, most drafting attorneys did not witness the undue influence because that all happened outside of their presence, outside of their office, before the person came to the office to do the new trust or the new trust amendment. So part of the purpose of deposing somebody is to find out not just what they know, but more importantly, what they don't know and where the limits of their testimony end. Because a witness cannot testify in court to something that they themselves did not witness or did not know. They have to have direct knowledge of what they're testifying to. And then another common element of evidence would be the financial records. So if somebody was taking assets from the elder before they died or doing some sort of weird financial transactions, you need to subpoena the financial records to find out what was going on there. And those financial documents ultimately could be evidence in your case. And then, of course, the bad actor would be deposed, and their testimony would also be evidence. So there's a lot of different people and documents that you can pull together to try to build your undue influence case. But unfortunately, what you're not going to have in most cases is direct evidence. So you're going to have to build this circle around your case and try to fill it in with as many good witnesses and documents as you can find to support your undue influence case. It's not the easiest thing in the world to do, but it's not impossible. But you do have to roll up your sleeves and get to work and find those witnesses and find those documents that are going to support your case. Albertson & Davidson is here to help you fight for your inheritance. Check out aldavlaw.com for our complete library of helpful legal videos and articles from your favorite California trust and will litigation law firm, Albertson & Davidson, LLP.